All right, so we are at the top of the hour. I know there's a lot of good content in today's lecture, so I'm actually very excited for the lecture today. So why don't we go ahead and get started? I know we've got most of our fellows here. We got a few still coming in, straggling in with the traffic jam. But for those of you who weren't here a few weeks ago, we have Barbara Opperwall with us again today. She is a palliative care nurse practitioner, worked with a few of the agencies around here, recently retired, but comes back and shares her knowledge and experience with us. And today is a great topic on capacity and surrogate decision-making. So with that, Barb, I'll turn it over to you, and you should be able to go ahead and share screen and get started.
Good morning, all. I wanted to say hello before I started. I have to give you a heads up that I'm notoriously lousy at noticing chats until I've stopped screen sharing. So if you have a question during, just speak up and I will be glad to entertain that. As Joel said, I'm a recently retired nurse practitioner. I most recently was working for Trillium Palliative and Faith Hospice, and part of that spectrum now Corewell Palliative Services. So that's kind of my most recent professional background. We all were a little worried about how retirement would go for me, and surprisingly, particularly to me, it actually suits me. So I'll respond to questions on that on the side and in the future if anybody has those. I'm going to move to my screen share now. Give me a minute. Alrighty. So the title of this conversation is Who Decides When the Patient Can't? I have no disclosures. That's a little bit of a history of my most recent travels this fall. Some of which you may recognize. Nurse practitioners rarely have disclosures, and palliative care folks also don't have disclosures often. That's required for the contact hour stuff. And so I just want you to be aware. We do have objectives, and I want you to be aware of those. We're going to talk about surrogate medical decision-making, particularly in our specialty. We're going to also talk about decision-making capacity and decision-making competence, which are two different things. And I'm going to throw in a little bit of advanced directive stuff on the side because we all need to know that. I'm going to start with my basic quickie elevator description of what I do. So when I was working in hospice and palliative care, and I have to tell you, actually now retired, I suppose to no surprise, running a very robust pro bono health, medical, and palliative care side business. So that for most medical people is always true, but it's been since I retired than ever. Will you tell people? We provide expert symptom management. People are very familiar with that. We are all very familiar with talking about that. It's one of our favorite things to do. But we also facilitate patient-centered decision-making in patients who have a serious or life-limiting illness. I'm going to share for myself that my interest in this particular topic about surrogate decision-making started very early in my career, and I am extremely invested in patient self-determination. And that probably is rooted in part in feminism from before several of you were born. But that self-determination as a person becomes very important to me, and to make that happen for patients as well. So I support patient self-determination as a core value, and it reflects the patient's right to choose their own destiny. Please know that I'm not going to address the inherent political and cultural bias in that statement. We'll talk about that in another lecture, particularly about implicit bias. But because not in every culture, not in every situation is it the patient's desire to determine their own destiny. But I believe it is the patient's right to do so, and I support that. Now, this is rooted for us in some very basic common law practices. If you are looking for one reference at the end that gives you all the information at this that you can put in someone's hand when you have a very dicey decision-making situation, I am so sorry that that's not the case, and it's probably why we're talking about this today. It has to do with statutes in Michigan, which we'll cover in a few minutes. But I want you to have the gestalt of this topic so that you can be guided by really good decision-making on your own part. So common law says in our country that every individual has the autonomy to self-determine, which includes their right to accept or refuse medical treatment. Now, management of medical treatment can be really complicated when the patient is not able to make reasonable decisions, or if that's called into question. But our legal system endorses strongly the principle that people are competent to make reasoned decisions unless it is demonstrated to be otherwise. And often we are coming in at that point. Now, in 1990, there was an additional federal act that is called the Patient Self-Determination Act. And this act is the act that required that we ask every patient, whether they enter our clinics or our hospitals or any other situation we are transacting with them, whether or not they have a proxy for healthcare decision-making. And that has been relegated usually to a clerical person at the door, asking the question, checking the box, and not much happens after that. Sometimes patients are handed a brochure of information, but the person that they're encountering rarely has the background or knowledge to even talk about this question. But institutions must tell patients that they have the right to participate and direct their own healthcare decisions, say yes or no to medical treatment, prepare an advance directive, and understand the policies that govern those rights. So how do we tell if a patient can safely make their own decisions? It actually seems like a simple question. So simple that we often don't pay attention to the fact that there are some strict requirements about that. It comes down to capacity versus competence. Are they too sick or sleepy to make a medical decision? We're going to talk about capacity first. Capacity is defined as whether or not a patient is capable of adequate medical decision making. This refers to their ability to use information about their illness and their treatment options and make a choice that fits with their own values. That seems pretty simple. Now, there are lots of myths about capacity. A lot of people think that decision-making capacity and competence aren't the same, and I'll talk to you about competency in a few minutes, but they are not the same. There's a myth that if you make a decision as a patient against medical advice, that you must lack decision-making capacity. That is also not true. People believe that decision-making capacity is all or nothing, that if you have lost part of your ability to process information, that you have no decision-making capacity at all. And I want to assure you that people usually can tell you or not whether they need to use the bathroom and whether or not they're thirsty or not. So people do have decision-making capacity about things, even if they have lost it partially. Some believe that if there's a cognitive impairment present, that the patient does not have any decision-making capacity. That is also false. People believe that lack of decision-making capacity is permanent, and that's not necessarily true at all. In fact, most of us, if we're under anesthesia, don't have decision-making capacity at that moment, but we expect that to fade when the anesthetic washes out. Some believe that patients with specific psychiatric disorders are not able to make their own decisions. That also is not true, and there's some actual specific statutes about that to protect that cadre of patients. And some believe that only psychiatrists and psychologists can assess decision-making capacity, and that's also not true. Let's take a look at the prevalence first. So this is just one pretty brief slide. It's fairly old, but actually still accurate. Those numbers haven't shifted. But if you look on the bottom right-hand corner, the patients with Parkinson's disease present in a nursing home, Alzheimer's, no surprise, or learning disabled, have very high percentages of incapacity. But if you look at just general medical inpatients, almost 25% or a little more than 25% can have an incident of incapacity during that hospitalization. And so these are patients we see very commonly and are diagnoses that we are regularly encountering. If we look at just age-related capacity, which became more interesting to me over the years, obviously. And we look at capacity, particularly in the month, weeks to days prior to death. And we see that more than a month out, 1 in 4 people who are in the dying process lose capacity or have capacity issues. And that obviously progresses. When we're at a week to hours before death, it's well over 50%. So a huge number of our patients are going to have incapacity at some point for making medical decisions. And that is a big reason why we are answering this question and talking about when do we have these conversations and how do we make sure that the patient's right and ability to self-determine is preserved when we get to this place, which is going to be for well over the majority of us. Another way to interpret those data is that note that 2/3 of Americans die of the 5 main chronic diseases: heart disease, cancer, stroke, COPD, and diabetes. And note that this slide has not been updated for the impact of COVID on these rankings. But with 2 to 4 years of decline prior to death and up to half or more having that loss of capacity sometimes in the last 2 years of their life. So when do we assess capacity? This is a graph comparing benefit versus patients accepting or refusing an intervention. And you can see that if an intervention has a likely benefit and patients accept the intervention, there's very low standard capacity assessment. We are all happy. The thing we're going to do benefits them. They're willing to accept it. So we all are going to kind of go, okay, seems fine. Same for if there's a likely poor outcome and they refuse it. Again, low standard capacity assessment because we are all happy. The patient doesn't want it and we don't want to do it, and so it doesn't happen. Capacity particularly is going to end up needing to be evaluated if there's a likely benefit or really low risk on our perception to the intervention, but they don't want it, they refuse it. That's a much higher standard for assessing capacity. Same for if it's likely a poor outcome or patients insist on it, we're going to really want to explore that decision making a little bit more. And that's pretty obvious to us, but I want you to be able to classify it so that you can defend it appropriately. Now, there are differing thresholds for a specific decision. For example, and these have legal implications, and I'm not using legal implications to threaten it, but to talk about our responsibility to proceed in a responsible and a legally supported way. If a decision will prolong life and existence and it's made in a rapid situation, the Good Samaritan rules are very protective. And so although many of you are may be reluctant, for example, to respond to an emergency situation, in that situation, Good Samaritan rules are very protective. And coincidentally, I actually had a long airplane ride in which no other medical person responded to what was a cardiac event just a few weeks ago. So that stuff happens. Actually, a Dutch-speaking pediatrician also responded, but he wasn't quite sure what to do with the adult man having a cardiac event. In contrast to this, if a decision has very high risk and will lead to end of life, the patient is a vulnerable adult, and there are higher protections and higher standards involved. Please remember, though, that the prevailing standard of practice, what we would normally do based on evidence and testimony of experts and case law, that prevailing standard of practice is always present, and we can rest in that. And so if you are really taking good care to practice in the standards of your profession, you're very well protected. A couple of things to consider when we're looking at surrogate decision-making and capacity. People who've had trauma, whether it's in childhood, in adulthood, or both, have a higher risk of capacity issues. Their symptom load is very likely to be higher. And so that trauma awareness becomes very important, being trauma informed. Implicit bias, I mentioned earlier. There are also sociocultural considerations, particularly if you are white and your patient is not, just beware that although some consider white culture to be the default culture, that's really completely inappropriate. Demonstrate your implicit bias and complete unawareness of those social and cultural considerations. So please be sensitive to that. There can be relationship subtext depending on who's present in the room, and everything is connected, all the stuff that's going on. Just remember, if something doesn't seem right, just ask more questions. There are 4 main components to capacity assessment. The patient has to be able to state a choice, that is, communicate. They have to understand the relevant information that would be pros and cons, risks and benefits, burdens and alternatives to the proposed treatment or decision. They have to understand it. The patient not only has to understand the situation, but they have to understand the implications of doing it or not doing it. So they have to appreciate the situation or the consequences. And the patient has to have a coherent thought process and be able to remember and use the information. And I share just this trick for people who are having changes in their cognitive ability, and I have questions about their stuff. Pay attention with the staff about when what they last ate, what they last did in terms of using of toileting themselves or being toileted. because patients who can remember those things usually actually are thinking pretty clearly. Patients who can't remember those things, or if they confabulate, it's a whole other thing. And please do not underestimate the ability of patients to confabulate, particularly people who are extroverted and gregarious. If there's been a slow cognitive decline, their capacity to confabulate well is quite astounding, actually, and sometimes quite entertaining. In the state of Michigan, capacity is determined by 2 physicians, but any caregiver can participate in the assessment. So your nurse practitioners and physician assistants can go in, they can do an assessment, they can document it, but 2 physicians are required to go in and verify that assessment. That assessment needs to cover those 4 components we just listed: communication, understanding with recall, appreciating the consequences, and reasoning through it. If you have access to neuropsych or psych, that can help. They approach it differently because they have constraints associated with psychiatric illnesses. This does require 2 signatures on a form. Your institution usually will have a form, or you can Google incapacity in Michigan. You'll get the 1-page form that has place for the statement of your assessment, what's lost in capacity, and places for your 2 signatures. Often getting the 2 signatures can be a little bit tricky. And so maintaining good relationships with your colleagues and understanding about this and understanding what you all need to do to maintain this for your patients. It's a protective thing for patients so that one person can't just take away medical decision-making capacity from a patient. But please note that once you both sign that form and declare that the patient lacks capacity, it takes a legal action by a judge to undo that. So 2 physicians can make it happen, and a judge has to undo it. So just take that step with great care. And patients actually know this sometimes more than healthcare providers. Now I'm going to share with you one of my famous completely unreadable slides. The references on the side, that's the part I actually want to point out to you. It's a little bit old, but it's classic. It's considered a classic in the field. And so it can be really helpful for you. And again, it gives you those 4 main criterion for understanding what capacity is. And it gives you a series of questions that you can ask that speak to that topic, what the patient's task is, how to approach it. And so it's a very useful kind of table to be. And then the slides are available. And so you can dig back into that and print that out for yourself if you need that. It's classic. It's probably going to fit with stuff you know. But if you like to have a pocket card, that's what this is. So how is capacity different from competence? Decision-making competence by US law is about mental capacity, which we've been talking about, of a patient to participate in legal proceedings or any kind of transaction, and what kind of condition they have to be responsible for their actions. This is a court-based judicial decision. Now, the judge will use medical input. They'll read those records. They'll see that assessment. But the question about competence can be raised by anyone. So it can be raised by healthcare staff. It can be raised by family. It can be raised by friends. It can be raised by political opponents. Now, consequently, the patient is quite well protected here, and the burden of proof is fairly high. If it is determined that the individual cannot make prudent decisions in their own interests, the court will assign a guardian to make decisions on the person's behalf. And in Michigan, if it's not an emergency, that takes usually three weeks. Pandemic made that longer. I think we're kind of rolling back down to that 3 to 4 week time, although an emergency guardian can be named on a very short basis. And an emergency guardian will only be designated if there's clear proof to the judge that the patient's life is in danger. Otherwise, a guardian ad litem or a temporary guardian will be appointed to do the investigation. Competence also is something that is considered decision specific. So some patients will lose their capacity to make healthcare decisions, but will retain their financial decision making, or vice versa. People will not have financial making opportunities. They will be declared incompetent for managing their money, but will still be considered competent to manage their healthcare and other aspects of their life. And that actually is fairly common. So if you have a competency issue, be sure it gets in your records so that you can read it. They're usually very short and very readable. It's just a paragraph that says this patient does not make financial decisions. Here's who's covering that for them, but they can make any and all medical decisions, for example, or they're completely reliant on their guardian. If a patient lacks capacity or is incompetent, one or the other, and there's an urgent medical decision, who decides? So I think we're pretty aware either a surrogate has been identified, usually through paperwork, or a court action, or we don't have one. And that's actually the ones that we really often get called in for. So you can identify a surrogate medical decision maker by an advance directive. That's the booklet that we have in all of our institutions. There are several different kinds that are established, and it's a statutory content in the state of Michigan, as in most states, and they vary a little bit, but not a lot. Medical durable power of attorney can be developed by attorneys in the state of Michigan. That's usually done along with a will or a trust. There could be a guardianship determination by the court, and that does need regular court certification. Please know, there is no next of kin in Michigan. There is no next of kin in Michigan for people who are alive. There are succession statutes in Michigan for what happens to your stuff after you die, but there is no statute about what happens to you while you are living. We'll talk more about that in a minute. I'm going to take a little sidebar around advance directives because it's one of the ways we can have the biggest impact here. An advance directive is paperwork, usually about 8 pages, that picks a patient advocate to make medical decisions if the patient is unable to do so. Please know, I think someone has to, someone should mute. It's invalidated in Michigan if you are divorced, but not if you are legally separated, unless stated specifically in the separation, if you name your ex-spouse. In addition, it may include wishes regarding a lot of different types of medical decision-making, including code status and views about life support and organ donation, and even funeral preferences. So when I spoke for the group when it was much smaller and we were all in the same room, I would ask the entire group whether or not they have an advance directive. And for years, I would be one of the only people who raised my hand in the room. Now, this Michigan Patient Self-Determination Act in 1991 began that series of statutes that require that we ask everyone if they have one. And although there's no required standard of when to start asking, the age of 50 is loosely recognized. So you can all kind of sit back and relax, I suppose. But after the age of 50, if any of your patients are over that age, it really is recognized as a standard of practice to ask about the advance directive. I believe that the standard really should demand that we work with patients about making one if they have any interest in doing so. But I want to take a sidebar about who is more likely to benefit from an advance directive. Very rarely, for example, do the fellows have their advance directives done. These are people younger than me who are under 40, many under 30, and have not been thinking a lot about that. But I used to talk to my younger colleagues and just say, between myself and someone who is 30, the likelihood statistically of a catastrophic healthcare event is obviously higher for someone in my age group. But if you think about the most likely catastrophic event, if the 30-year-old and myself each have a catastrophic event, which of us is more likely to need an advance directive? And without being too crude, it's not me. My catastrophic events are likely to be oncologic, in which I will retain my capacity, or cardiac, in which I may or may not, but generally will recover my capacity. Whereas for someone who is 30, the most likely catastrophic healthcare event is traumatic, in which there is loss of brain function. And so please know a few things about completing an advance directive. A patient must name their own advance directive. You cannot hand this paperwork to the family and tell them to fill it out if you already know the patient lacks capacity. There's a little bit more depth that has to be pursued there. Please encourage them to name at least one surrogate alternate. So name the person that they want to make their decisions and the backup. I can't tell you how many people are in traumatic, just car accidents. The surrogate is in surgery getting their knee fixed, and the patient lacks capacity, and there's no alternate surrogate. So we're back to 0 surrogates for decision making. On the document, 2 witnesses to the patient's signature are required. They cannot be the persons that the patient picks to be their surrogate. They should not be immediate family members because we're looking at preventing appearance of coercion, and they cannot be the healthcare team. So y'all cannot sign advance directives in the hospital. You can sign them for your friends and family as is appropriate, but not in your role as a healthcare provider. So if you in any way could be perceived to have some kind of healthcare responsibility to a client, you cannot be witnessing their advance directive. I did used to share, and someone actually asked me about that last week, that I thought in my retirement, one of my jobs might be to call my friends in the care management departments of the major hospitals in the area and tell them that I was going to get a cup of coffee and would be in their institution for 2 hours each morning, so that if they needed me to stroll in their corridor and be their random visitor who signed advance directives, I was going to be willing to do that. It was going to be my gift to mankind. I haven't actually done that lately. Pandemic kind of took care of that, but obtaining the witnesses often is one of the biggest challenges in completing the paperwork. The acceptance by the surrogate can happen later. It can even be done by phone with witnesses. Please be sure that your patient keeps their original and give them extra copies to hand out to people. I can't tell you how many times they fill it out, it gets handed in to be scanned into the record, and that black hole for documents is where so many advance directives can be lost to us. Patients don't really realize that they need that document or that their surrogate is going to need one. Because if they take it home and put it in their safe and the surrogate can't get to it to prove it, it's like it doesn't exist. Excuse me. Sorry about that. So how's that different from medical durable power of attorney paperwork? So medical durable power of attorney work is a section of paperwork prepared always by an attorney. Please note that patients will pull up for you a general durable power of attorney. It's the most common document. They're aging, they've picked one of their children to be their general durable power of attorney to have access to their checkbook. It does not usually cover medical decision-making. It usually has a boilerplate statement that the child may have access, or whoever they picked may have access to their medical records, but it does not say anything about being their patient advocate or durable power of medical attorney. Patients also often think that if they have a will, that the executor of their will is also their medical power of attorney. This is not true. In the last 10 years, medical durable power of attorney work is required in Michigan. Any attorney prepared paperwork for any will or any trust to be included in that, but often patients are really not sure what happened. That's such a big pile of paperwork. The paperwork must specify who the surrogate decision makers, that is, patient advocates, are, number 1 and following. And again, these may specify wishes and preferences, but they're often very boilerplate, as in, if the medical team believes that there's no chance, in quotes, for my survival, then they can stop treatment. It's usually not much more helpful than that, unless they have been specifically requested to give details. And please note, living wills are not binding in Michigan. So a lot of people, they are binding in Florida, they are binding in Arizona. So a lot of people get their paperwork done in the sun while they're out of state, and they come back here and get sick with their kids, and they have a living will. They think it's all lined up, but they are not binding. So then, although they're advisory, you also still have to have that deep conversation. Just a couple of side words about guardianship and conservatorship. There are a lot of different kinds of guardianship, and the kinds we see are those of a legally incapacitated individual, and that can be full or partial. It can be a guardian ad litem. This is the person appointed by the judge when the initial petition comes in to explore the situation and figure out what it is. They have no decision-making capacity. So they'll be asking you questions. They'll be coming into the hospital if the patient's hospitalized, and we'll be thinking, oh, please tell us what's the answer to this. They will not have any decision-making capacity. They have to discuss everything with the judge. A temporary guardian can be appointed, and they are limited by the court on what their decisions are, and usually they do not have the ability designated for them to make decisions about code status, although the full guardian does. And then there are guardianships of developmentally disabled people, and those also are full or partial and have different standards about them, although the state of Michigan is taking great strides to make them all match. Again, an unreadable slide, but I want to use it to let you know about a reference. So this is a state by state, so Maine, Maryland, Michigan, recording of whether there are succession rules for after death and whether there are succession rules for medical stuff. And in the state of Michigan, it just says a member of the immediate family or the next of kin, not specified, which is helpful to us, 0, because Michigan does not define the next of kin for medical decision making. This has been an issue since 2016 when this particular slide was developed, and it has not been improved since that time. Also, please know, even if we're trying to make tracks about what we assume next of kin means, there is no common law marriage in Michigan. 8 states still have statutes about common law. A certain amount of time together is the same as having been married with a license. It's typically 5 to 7 years of cohabitation. These do count across state lines. So if you have a common law marriage in one of the states that permits it, then it is a common law marriage, a legal marriage in the state of Michigan. And people who have a common law marriage, they often don't realize it, but if they separate, need a divorce, or they're considered still legally married and can be bigamous. So there's a lot of hot stuff around that one, and you just have to pay attention to the risk. You want to precisely identify the family members who are present. Take care to chart accurately. Spouse, husband, and wife means they are legally married. So if you say wife at the bedside and you haven't checked, in our culture today, you're as likely to be wrong about that as you are to be right. So please, please, please verify if they're legally married. Please call them a domestic partner if they are not legally married. And please know, patients and families will fudge the truth here, which can have significant impact, particularly if they have reconciled with an ex-spouse so that they are not married but formerly were, maybe wearing their rings from before but never actually remarried. So there can be some real murky in there. Just be a heads up to Michigan. And this obviously, since it's Michigan, is different from the states that have common law or that have defined succession. So what are we stuck with in Michigan? In Michigan, the process that we help identify surrogate decision-making is based on applicable Michigan case law. And I want to tell you, when you want to get access to that case law, it is not in one book or journal, and it is behind a pretty strong firewall for which you have to pay a substantial fee to penetrate. And so my access to this information, in part, and it's fully accessible to you, is based on the fact that for some reason, both my family and my husband's family are full of lawyers. You can just Google Opperwall, it's his last name, to get a taste of it. And that's not even the half of it because it doesn't include the outlaws. And so it made for some very interesting Thanksgiving dinner kind of conversations, but I really needed to have a little help penetrating that wall. In applicable Michigan case law, decision-making can be made in consensus by the first-degree relatives. First-degree relatives are defined as the legal spouse, any adult children, that's 18 and over, any living siblings, and the parents, whether they are competent or not. So that has to be kind of addressed. In addition, in Michigan case law, there is a space for those who by proximity are presumed to know the patient's wishes. So if the only family is an estranged niece who lives out of state, and the patient is brought in by their neighbor who feeds them and takes care of them and brings them to their medical appointments, that neighbor is presumed by proximity to know the patient's wishes and can have a place in patient's decision-making, and you can listen to them. And then finally, remember that the usual standard of care is very protective for all of us here. And so if we have a situation in which we can't seem to get an answer, but the usual standard of care is obvious, then we can explore that. It's always appropriate to have ethics involved just to make sure that your own bias is not affecting your decision about usual standard. So how do you identify the people who can participate in the decision-making? It sounds easy, and it is easy, and yet it's not. I mean, you can ask the patient, but how often do we do that? Or do we rely on others? How often have you said to a staff outside the room, who is that in there with them? counting on the staff to have accurately identified them. Please, please be careful. I can't tell you how many times that I have had people from a patient's church, a priest and a deacon, come out and say, "Who was that?" And they asked us about whether the patient should have this procedure or not. Just be careful. Ask the patient who's present with them. It's a useful capacity question, and it can help you figure out who's who. Ask the visitors who they are. Hey, how do you belong to the patient? Check the records to see what it says in terms of who the family are, in case the patient identified family members or contact people while they still were able to provide that information. And call a family member and just say, "Hey, tell me about the family. We want to know who cares about the patient." Be sure that the patient's support team are involved in the stuff that do that. They can come alongside and just get that stuff documented clearly. And if you see inconsistencies in the documentation, then figure out how you're going to resolve those and get that taken care of. Now, there is no Michigan default surrogate consent statute. It is not a thing. It's only that Healthcare Disclosure and Consent Act asking people about it. There's no specification that a person can orally name a surrogate. If a patient tells me who they would want to speak for them, if they were too sick or sleepy to speak for themselves, I write that in my notes. It's part of the information you're building about the patient, but that lets me know we better get that into the paperwork because that may not happen. The priority of surrogates, if there is no paperwork, is not specified. As I said, no succession in Michigan. That means that a spouse does not get a higher weight of decision-making over a child or a parent in this state. It's equal. And so if a patient really wants a specific person to make their decisions, it needs to be specified. As many of us have, I'm pretty specific about my wishes if I start to lose capacity. And I discuss that with my proxy. One of my children has shared very clearly she is not sure she could honor my wishes. And so it's really important to me that that be protective for her as well as for me. Think also about what your consensus committee might be if you don't have an advance directive. So on your fingers, you don't have to show me. I used to make people hold up their hands. On your fingers, you have your parents, and you have your siblings, and you have your children. So some people's committees can be 5, 6, 7, 8, or more people who have to have consensus. It's not a majority rules kind of deal. It's consensus. And if they do not agree, there is no process to resolve that. There's no standard for decision-making in our state by statute, and there's no judicial recourse. If equal priority surrogates, that means siblings and parents or spouses, do not agree with each other. And this probably is the most persuasive piece about why designating a patient advocate is really, really important. So in Michigan, if there is no identified surrogate and the patient lacks capacity, the decision-making is managed by family consensus, and you have to have a good faith effort to find estranged family members. And it's okay if you've made multiple attempts to contact someone and cannot reach them, to document that and say, although we have attempted to contact the brother in California named blah, blah, we have been unable to reach them, but we'll continue to attempt to do so. An alternative is a guardianship petition. Facilities are notoriously kind of reluctant to do this for a couple of reasons. One, it's expensive. Two, if a hospital, for example, petitions for guardianship, it's really likely that they won't see the merits of it because the guardian will probably not be appointed until after the patient leaves. And so there's a tendency for an organization to quietly kick that can down the road. And we often wonder why they aren't proceeding on that when it's obvious. But it's often a very specific business decision. And in terms of systemic issues with surrogate decision-making, that business decision can stand in the way of good patient care. And that is the kind of thing that needs to be addressed outside of the patient unit or outside of the patient thing, but in the administrative levels of the organization. Please know that physicians can make a decision about medical appropriateness of care. In other words, if a patient demands something, but you think it's inappropriate, you do not have to do it. You want to have ethics input if you think a patient needs something because it's medically appropriate and they're refusing. It's a little bit different decision. It's that high risk area. Some institutions attempt with their legal departments to establish policy about succession. They'll define in their organization who they think next of kin is. And there's really unclear standing for that in Michigan courts. So just be a little bit careful about that. It's not really going to hound you a whole lot, but you want to do the right thing. And institutions in Michigan are not permitted to say who the next of kin is or who the surrogate decision maker is. So I had a kind of interesting question recently, which was, do we have to declare a patient to lack capacity for the identified surrogate to make decisions? And the answer to that is no. So identifying the surrogate becomes really, really important because you then can very carefully build a process of involving them in each step of the patient's care, even though the patient is still making decisions. And you can share with the patient, I want your surrogate to be with us so that they clearly know your wishes. So if the time comes when you cannot speak for yourself, they are present and can do that. If a patient is in decline and near the end of life, we do not have to declare them to lack capacity before we can listen to the identified surrogate if we have documented that the surrogate has been present for a substantial time in all the decisions, clearly knows the patient's wishes, and we are proceeding with the plan that the patient, the surrogate, and you have put together. In that situation, you have all the decision-making stuff you have in place. You have to document it, but you do not have to go through the incapacity stuff in that situation, at least not all the time. Sometimes you're going to need to, but most of the time you don't need to. I like to ask, who would decide for you if you were too sick or sleepy to make a medical decision? If you're not sure, you probably want to work on that. If you thought it was going to be your spouse and you don't have any paperwork, you probably want to do something about that. If you don't know who it is for your patient, you probably want to do something about that. And that's my challenge to you today. In the slides, there are several key references. And just a quick view of the Tetons. There are 3 elk and a mother bear down there. I'm going to stop the share and we will open this up for questions. Anybody, any questions for me?
Hi, Barb. This is Ken Henson. Can you hear me?
Yes.
Yeah, I'm sorry, I'm driving. Just want to make sure. I wanted to go back to.
And now no.
Oh, did you lose me? Can you hear me now?
And we may have all frozen. Ken, I did not hear you. Can you say it again?
Yeah, it's a bad area that's typically forest cell connection. Can you hear me now?
I'm not hearing Ken's question. We can either put it in the chat or we can give him a few minutes.
Ken, why don't you try again in a couple of minutes and we'll see if we can hear you. Other questions?
Gretchen has a question in the chat. Can I discuss more about the process for reversing an activated medical power of attorney? They've received different counsel from the hospital. So there's a common belief that if we activate and declare a person to lack capacity, that we can just undo it and somehow chart in our notes or do another kind of document that says that they lack capacity, but that's really not supported by Michigan statutes or by case law. Once we declare them to lack capacity, protections, court protections as a vulnerable adult apply. And generally speaking, if you've activated it, they're going to need to make a petition to probate court to undo that or request the hospital to remove that completely from their records and declare that it was an error, which they'll never do so because it wasn't. I wish that wasn't true.
So as a follow-up question to that, can you hear me okay?
Mhm.
So as a follow-up question, I just wonder then why would we ever need to actually activate if it has the implications of needing to go to court to reverse that, if the decisions can be fluid and don't require that to be activated in the first place? If we can just listen to the surrogate decision maker, why go through the whole process?
So the activation process is a gray and murky area. You have correctly identified that. And we go through the activation process if there is any distress about who the surrogate is, and to make things go smoothly for the patient and the surrogate, particularly if they'll be moving through the system through different facilities and different areas, so that doesn't have to be reestablished in each area. The part about not declaring them to lack capacity really only applies if we know that we are going to be caring for them through the end. And so there are many situations where you want to establish that indeed this niece is the surrogate decision maker, so that all the other people who are involved or not involved, every other institution that is wondering or not wondering, that the patient and that surrogate are protected together as they're moving through. That's kind of a brief answer because it's kind of a situation by situation thing, but did that help?
It does. I just think about decision-making capacity being a fluid idea in many of our patients who have a isolated and temporary event that oftentimes we're asked to complete that, but that may not be something that is lasting for the months or years to come as a permanent action.
Yep, it's very serious consideration. If you truly believe that the lack of capacity event is temporary, the patient's self-determination is very well protected by establishing, and if you believe that it will resolve under your care particularly, you can really just involve the surrogate all along, keep that documenting going well, and report that the patient's decision-making clarity is emerging again, and thank the surrogate for that participation in your notes, and you don't have to go through that declaration of incapacity.
Hey, Bart, this is Ken again. Can you hear me now?
Yeah, I can. Let's give it a go.
Yeah, I'm sorry, I didn't see, again, I'm driving. I didn't see who was speaking prior. I guess historically for an institution to take away the patient's capacity, I've seen it very rarely done. And usually it's in a situation of withdrawing care. That's being, if patient and or family is requesting inappropriate care. But for patients that lack capacity, for example, somebody comes in septic, they're delirious, they don't have capacity. You have implied consent during emergency treatment, but then for further care, you might have to determine they do not have capacity. But then, days later, after resuscitation, they may regain capacity. And so I was under the impression as well that if you enact the two physician signature, that was really a specific incident and didn't necessarily follow them, but I could be wrong.
So I'm not a lawyer, and you're gonna want to talk with your organization about that and be sure their policies are very specific about it. You actually may have accidentally raised another very interesting issue, which is how far does implied consent apply? And implied consent is we kind of rest on it sometimes, but actually the standard that applies more accurately is the current standard of care and the patient's risk of loss of life or limb. And so we might, believe it or not.
Yeah, I agree 100%. I like to use a sliding scale.
Yeah.
For example, we don't get written consent to start an IV. We get verbal consent.
Yeah.
Yet, I think any neurosurgeon that did a craniotomy without written consent and careful discussion of risk benefits would get in a lot of trouble. And I my joke is implied consent is the 250-pound 17-year-old in the emergency department who doesn't want an ID. And if he's refusing it, he's not getting an ID until you can talk him into it, because he's going to be able to fight everybody off. So yeah, there's different scenarios that you have to take into consideration. So
yeah, and so anytime you're thinking implied consent, you're also going to be looking at prevailing standard of care. And as long as you have those together, and then the overarching piece will be at what point are we at risk of life or limb, and then a whole new standard applies.
great, yeah. Thanks.
No, good question. This is dicey, and there certainly are those very dramatic situations that we all have had at least a few stories about, in which it's really, really difficult, where we are having a big hot mess. And so those stand in the way. But the truth is, it's often a lot softer for us. And the importance really is having those surrogates identified early and involving them each step of the way, even if it's virtually, so that you can make sure that the patient's wishes, that self-determination, is what's your priority. And your documentation about that is critical, but it's extremely supportive. And so those conversations, particularly together with the proposed surrogate, are really critical. Let's see, I think there's another question. Mentioning needing family consensus if there's no surrogate, does this imply all of the family members, some of them, a set percentage? Oh, such a good question. So I'm going to repeat about family consensus in the definition. So truly, in case law, family consensus is all of the first degree relatives. It is the parents, it is the children, it is the siblings, and the spouse, a legal spouse, not a common law spouse. And so I want to emphasize that culturally, a huge number of patients, approaching half, the partner at the bedside is a domestic partner, not a legal spouse. And in the state of Michigan, a domestic partner has no standing in decision-making other than proximity. And so if you know you have a domestic partner situation, particularly if you know your patient wants the domestic partner to participate or be the surrogate, it is really critical for them to get that paperwork taken care of. And you can hope that you have a family that'll integrate that partner in, but that is not always the case. So yes, it is every single family member. And if there are estranged family members, if there are children they never speak to, you still have to do due diligence to vigilantly try to track them down to see if they want to participate in the decision-making. If they refuse, you may document that Brother Joe refuses to participate in medical decision-making, but you still have to contact him every time there's a decision to offer him the opportunity to change his mind and participate again. So family consent.
Right?
Yeah.
Can you hear me?
Yeah, go ahead and repeat that.
Hi, Barb. I'm just, so that was my question, and it's very fascinating, and that's state specific to Michigan, right?
Yes, correct.
And I'm not downing it, but it just seems like it's very, very tedious trying to find out when you got somebody in Oregon and someone in Texas, and some of these people don't even want to be known or called, and yet you're still needing to contact them, and then they look at you, I guess what you're saying, and they say, well, I don't want to be a part of this. But then if you're saying another decision is made, you still have to call them again? Or can you just, I mean, when do they then have the right to say, leave me alone? I'm just wondering how this all plays out,
Thankfully, the amount of times that actually occurs is on the lower side. So I'm gonna call it out gently as kind of an exceptional piece, but then I'm going to acknowledge it is extremely tiresome. And I raise those possibilities because it really emphasizes, number one, the importance of us making sure that surrogate that the patient wants is established early. And so I'm going to use your comment in part to just demonstrate how important it is that we have those conversations early and that we verify whether or not that has happened, that we don't necessarily just dish that off to somebody to do, but we have the conversations get the documentation in place, and start to record who those family members are so that we can avoid that very situation. In a dicey situation, and there are plenty of them, we just have to do due diligence. The good news is that you don't personally have to call them all, but you have to make sure that your care manager or someone in your staff has made those calls and that the response of the individuals are documented. Remember that if it's an urgent situation, prevailing standard of care, risk of life or limb, taking the time out to make those frustrating calls is exceptioned. And so it's not set as an unreasonable standard, but much more as please know how it is in Michigan and how critically important for self-determination of a patient it is that they take care of this business. And know that it's usually a process. I mean, this is what I have done for decades. And it took me more than a year and a half to get mine taken care of because I knew who my surrogate would be. It was my spouse. But my oldest child did not want to be the alternate. And it took us a huge number of family conversations to get through that. I see another question. I'm going to get to that. I'm going to share a personal story. So I was my dad's medical power of attorney. It was easy. He avoided medical care pretty much his entire life and did not feel like it was time at the end of his life to start entertaining it. So he wanted nothing, and we were able to move quite through that quite easily. My mom, for whom he was married a really long time and is still living at almost 90, asked at the same time if I would be her medical power of attorney. Now, I want to let you know that my mom is a very religious person, and I owe my faith formation to her. So I'm not meaning to speak ill of her faith, but she views medical care as a gift from God, and that those gifts as such should be sampled 100%. And I had to say to my mom, I am so sorry, but I cannot be your medical power of attorney. It should be Sue, it's my sister, because she won't know what you're facing in terms of suffering that I will and can't say no. So if you want everything, you just have Sue, and then she can tell me when she can come crying to me. And so that was a Thanksgiving to remember. I just want to let you know. And so it was thinking words for her, which no one else had with her, no one in her medical team. Thinking words for her that there would be things that I could not say yes to because I was so worried about her burden of suffering. And so those conversations take time. They take time with families, with patients to think about. So be sure that you allow that. I think we have one more question that I think we need to be done. Okay, do I have suggestions in terms of getting advanced care plans witnessed? There often are people who are interested but not allowed to have staff or family witness. It slows the process. How do we do it in a facility? So, as I said, most of the challenge in getting advanced care plans done, first of all, is patients look at that form and there are two sections. The first is the designated surrogate and the second is the wishes, and they always get stalled out on the wishes. And I share with them that the wishes are really conversation points to talk about with their surrogate, and that the get started by getting the patient advocate identified. The next place people get stalled out is on the witnesses. And I share with you, it is a huge problem for the way that the statute is written. And advanced directives are statutory. That means the content is specified by the statute in Michigan, and the witnessing requirements are specified in the statute. And so truly, I often would cultivate, if I had family members who were around for a very long time, I would cultivate corridor strolls. And someone who witnesses it just has to witness that they see the patient sign it, even from a doorway. You don't have to violate HIPAA, and they sign that they saw the witness sign it. They don't need to know the business. They don't need to read the document. They just need to witness that the patient signed it. So anyway, I think we need to close because I think we all need to move on. Once again, I had a lovely time speaking with you all, and I wish you all the well in your day.
Well, thank you very much, Barb. Always a pleasure to have you join us. And as always, it promotes a lively discussion. So I'm glad we could do this.
Thank you all. Take care.